Yeah, this was before the court hearing today. As you can see, the people you saw standing were Bright Chimezie, Chidieber with Benjamin Mmadubugwu, as well as David Nwawuise. And here is you are seeing them. The first picture you saw Barrister Lawyer Barrister Fanny Jeffo. Of course, this is that. Let's hear from Barrister Jeffo.
Today, of course, you are aware that the charge filed against Bright Chimezie, Benjamin Mmadubugwu, David, and the Chidieber was the charge was pending since 2015. 2016, 2017. They were jointly charged with Mmadubugwu and before it was separated. So, and they came up today for hearing because they have been separated. So, Nandi, Mmadubugwu hasn't been discharged. So, their own came up today for hearing. However, before now, we have filed an application, notice of protection, challenging the decision of the court to hear the charge, to control the trial, on the ground that the 3-count charge filed against them contains elements of alleged offenses that were allegedly committed outside the jurisdiction of the Federal Court of Abuja. So, as such, that we have to go back to where the allegations emanated from and where the alleged acts took place from. So, and it's a fundamental issue, also anchored on 11 portions of the law, like Section 45 of the Federal High Court Act, which is very clear on what will happen where a person, a citizen, is being accused of committing an offense in a division of a Federal High Court, or probably in a location outside the jurisdiction of the Federal High Court, seized of the case, seized of the matter. The law says the person must be taken back to where the alleged acts emanated from. Are you with me?
Yeah.
So, we don't actually want to go into the merit or otherwise of the allegations, because that should be the second bite we're going to have at the charge when it's eventually transferred. So, because the 3-count charge as constituted are not only bogus, 3-count charge as constituted are not only bogus, but empty and frivolous. In fact, as a matter of fact, I don't see any reason why they should be coming to court to defend that bogus charge. But as law-abiding citizens that will be coming to ensure that it ends well. The application was taken today on the merits, adjourned to the 5th of September 2022, of 5th of December 2022 for ruling. So, and we are hopeful because this application is anchored on strong judicial authorities, like the Supreme Court in the case of Suleiman against FRN, which extends very compelling authority that has to do with issue of criminal jurisdiction of Federal Court. So, in that case, even the trial commences in Federal Court Lagos on alleged act that took place in Kwara State. Then they proceeded to full trial, and they were to judgment in Federal Court Lagos. From there, the Court of Appeal eventually to Supreme Court. Supreme Court declared the trial that took place in Federal Court and consequent hearing before the Court of Appeal Lagos State as exercise in futility, because they ought to have been charged before Federal Court Kwara Ilori Division, because of the fact that the alleged acts constituting the alleged offenses took place at Kwara State. So, which is very, very compelling on our own case. The issue of receiving information of a broadcast made in London, the charge count 1 was specific that the information was received at Enugu and Anambra. Bright Chimezie in this case was arrested in Akwa Ibom State. The second offense he was being accused of committing is offense of importation of transmitter, which they found at Obolosizo. These are acts within the confines, within the jurisdiction of Federal Court in Enugu and Anambra. I don't know what he's doing here. Chidieber and David Nwawuise were also accused of frivolous offense of making broadcasts from London. Tell me Chidieber and Bright and David Nwawuise, even all of them, apart from them, Benjamin Mmadubugwu who has been in Russia. has David Nwawuise and Chidieber and the bride, have they traveled to London before? Yeah? So tell me how they can make a broadcast from London and to consider offense in this country. That will tell you how frivolous and childish and empty the charge is. But without prejudice to the merit or otherwise of the charge, we are not talking about it now. We're going to, when we get to that bridge, we'll cross it. What we're talking about, what's our major preoccupation at this point is for the charge to be transferred, the matter to be transferred to Anambra and Oka, Anambra and wherever the charge they preferred. So when we get to the bridge, we'll cross that part. So, all the 3 count charges standing today against them constitute elements and acts allegedly took place in Anambra and Enugu. That's all. So I wonder, I wonder what they're doing in Abuja here. There's no business coming to Abuja. So we should go there. We have Federal High Court there. We have Federal High Court in Abuja, in Oka. We have Federal High Court in Enugu. We also have Federal High Court in Port Harcourt and Akwa Ibom, if the case be. So it was a very robust argument that was taken today and adjourned for ruling. And we're optimistic, believing that the court will find merit on application and grant same, at least to save them the transport of coming to Abuja. This stress, the inconveniences, the security threats they are being exposed to by coming to Abuja. So whenever the matter is coming up, so when they have a convenient forum where they will go to take the charge to face the trial. So that's all. That's the purport of the essence of the application taken today. And we are hopeful that on 5th of December 2022 that something good will happen. Because we operate within the ambit of law and we have placed our facts and laws before the courts, awaiting the court to do the needful. So thank you so much.
Thank you very much. As we were saying, we heard about the application for transfer of case to the region where allegedly these crimes were committed. And what I would like you to explain to Biafrans is, for instance, if this application is granted as it's been fixed to be ruled on the 5th of December 2022, if this application is granted, does it mean that the whole case is going to start afresh again, or they're going to start from where it stopped here in Abuja?
Unfortunately,
because as you said earlier on, this case started ever since 2015, and since then there have not been anything that is coming.
Procedurally, when a matter is transferred to a new judge, in this present case, if application is granted as prayed, and consequently or subsequently transferred to either Anambra or Federal High Court to start afresh for trial. The trial will commence in November. I want to call it over, starting afresh. So it means that all evidence given so far in the matter will start afresh. But of course, someone has given evidence in the matter sometime in 2017. So, and to start afresh. So, and we have other strategies lined up towards resolving the issue, towards addressing the incompetence of the charge itself. We will not come to that now. So, which I may not be able to discuss here. So, but I can assure you that there will be good. There are robust strategies, legal strategies we are going to adopt to ensure that once the charge is taken into another jurisdiction, we address the competence otherwise. Because the charge as it constitutes today is not disclosing any offense. It will shock you to note.
Yeah, so far that's the update from today's court's hearing. The situation in the Zoological Republic. The Nigerian government has nothing to offer. Nothing at all that a common man can hold up to. And this is how they continue misbehaving at any point in time. The issue that they should have settled within Biafran land, Biafran territory, either in Enugu, Anambra, Iguacha, or they took it to Abuja, and since then, since 2015, 2016, till 2017, down to this day, this is how the zoo government has been postponing, adjourning, and re-adjourning. When I'm talking about the judiciary system in the Zoological Republic, some people don't understand. If you have never been there, man, you don't understand what is going on. You will never understand. I tell you, the zoo, when it comes to the judiciary, it's nothing. It's nothing. Nothing to write home about. So that's that. We thank our legal team. We thank Barrister Ifeanyi Ejiofor. You know, very often we refer to Barrister Ejiofor, Barrister Aloy Ejimakor. There are so many other people whom we do not really know their names, and that's why very often I prefer using the name the legal team, because so many of them are still doing the good job, underground job, and I think our greetings should equally go to them, yes, so that they will equally understand that they are dear to us, because Barrister Ejiofor and Barrister Aloy Ejimakor alone cannot handle the things that are involved in it. So it is a teamwork, and we must give kudos to them, the entire legal team, to have worked with IPOB sincerely from the bottom of their hearts. So when you think about the 100 persons that Mazi Nnamdi Kanu needed, I assure you, I tell you, these legal teams are involved. Or of course, sometimes the 100 persons that Mazi Nnamdi Kanu used to talk might not be literal 100 person. Yes, it might not be literal. So these are, some people might not really understand it the way it is. We thank you for following up, and we thank Umuchukwu writer for covering this particular interview as well. We give Umuchukwu writers kudos for all the efforts that they are putting in the restoration of Biafra struggle, Biafra nation, in everything. They have been moving far and wide from Abuja to our own area to Biafra land, covering events at even the most critical situation. They are there. So we give them thanks in everything that is going on. Thank you all for listening.